Okay, today we're going to cover the topic of deeds relating to estate planning. So what I'm talking about is real property deeds. In order for a trust to control any asset, it has to be labeled in the name of the trust. And in order to get real property, home, rental, land, whatever, into a trust, you have to do some kind of deed. Some people say grant deed, trust transfer deed, quitclaim deed. And we're just going to cover the overall components of what is in a deed. This section of the form needs to be left blank for the county to stamp when they record the deed for public record. And if you want to put who's requesting the recording, you can put it here. This is where the deed's going to get mailed back to after the county gets done recording it for the public record. And this is important. It needs to say mail tax statements to. So the county knows where to send real property taxes. You have to have this at least 3 inches for the county and some good margins, or they will not record it. Okay, in this case, we're going to be talking about granting a deed to a revocable trust. And there are revenue and taxation codes. When you go to try to record a deed, the county wants to charge you taxes and things. And that comes from the Revenue and Taxation Code of California. And there are various taxes, and I'll show you where to get those codes there here in a minute. But so under this tax code section 11930, they cannot charge you extra to record a deed when you're just transferring from you to your revocable trust. So you give them the citation of the statute and say you're not getting any tax. Another tax here is government code 27388. This one is normally $75, but if it's to a dwelling unit, to an owner occupier, then you give them this section and saying it's exempt. Okay, in this hypothetical deed, we're granting it from a person. The grantor grants to this person as trustee of this hypothetical trust. Okay, so, and this person's called the grantee, the receiver, and the grantor is the giver. And then you describe what interest you're giving or what you have to give. So if I own the property 100% in my name, Rex Crandall, then I can say I, Rex Crandall, grant all the property to my revocable trust. And so it goes from a person to a person as trustee of a trust. A trust by itself cannot own property. It must have an individual to act as trustee. And then we're reciting here, there's covenants, conditions, restrictions. These are in the title. And you describe what you're giving, and then we'll get to a legal description pretty soon here. You write the date when you signed it, and when you're creating a deed, it's real important to make sure and double check, triple check that this assessor parcel number is correct. You would take it from the last recorded deed. And then right after that, we need a notary to witness the deed, or you're not going to be able to get it recorded. So it says that this person saw the signer signing right on this in their possession. Okay, so the next thing we're going to look for here is a legal description And let's see, start here, Adobe. Okay. Let's see, transfer. So in addition to having a deed, you're going to need to have a legal description. And a legal description is not the street address. You, the assessor assigns a unique number to each parcel, and that's how the property tax bill comes out. And on a deed, you need to tell the world what is that particular parcel number for the county. So after you do the notary, which relates to the deed, there's another component called the legal description. And this might be, what you do is you take the legal description from the prior deed. It has to match the property legal description that came from deeds before. And it's very important. And when I'm writing them, I take the prior wording, and it might be, 500 feet from the river to the mound and the tree and the corner of another parcel, and a lot of descriptions that I don't fully understand. And to make sure that it goes to the right place in the recorder, I put the parcel number, and then I put commonly known as, and this hypothetical address. So this is what people usually use, the address, but you can't do that because parcel numbers identify the property, and postal service issues addresses. So they're two different agencies. And then in order to get your document recorded with the county, you have to prepare and file what's called a preliminary change of ownership report. In this case, the form number is California Board of Equalization, Form 502A, as in Alpha. And what this does, it asks you a bunch of questions about the deed. And if you try to record a deed without this, you'll get a $20 fine. So nobody does it that way. So what the purpose of the preliminary change of ownership report is to tell the county assessor whether or not they can increase your property tax. So they're asking you all kinds of questions to see if they can get more property tax assessed. So in the first part, you get the address, physical address, and you have to have the parcel number. And seller and buyer, that would be the same person if it's you going to your trust. This is a principal residence. Since when? You put the date. Mail the property tax statements again. Where do you want them sent to? And then this is a series of questions that might have income tax impact, not income tax, real property tax impact. And whether it's between spouses, domestic partners, there's all these different reasons. And what we're concerned about here today, that it's a property, is a transfer of property to or from a revocable trust that may be revoked by the transferor and is for the benefit of who? And in this case, the transferor, it's for the benefit of the transferor. And in this scenario, there would not be a way to have it reassessed. So you have to look at the circumstances. Frequently, proportional interest stays the same. If there are 3 people own it and then you deed it to 2 people, then they're going to reassess a small percentage because the ownership changed, ownership interest. Then on page 2, a lot of this doesn't apply. Put the parcel number. Is a partial interest being transferred? No. If you were buying the property, you would list this section. This page 2 of, we call the preliminary change of ownership. Everybody calls it P-Corp. So what's your P-Corp have in it? Property information, this single family residence. And they ask you a bunch of questions. And property condition, I usually aim towards the less condition. And then you would sign it as the transferee and print out your name, date it, your title, telephone, email is optional. So you're always going to be filling out a PCOR with every kind of deed that you are whatever prepare. One of the most common deeds is a grant deed. And I normally use grant deeds. Everybody wants a quit claim. I don't use them that much, don't like them, because there's no warranties of title. If you use a grant deed, you're telling the recipient and the world, I own this. I'm saying that I'm the only owner, I have the right to transfer, and that there's a guarantee of title. So if this was a guarantee, I can create a quitclaim deed and not break the law by saying I'm going to quitclaim all my ownership interest in the Golden Gate Bridge to you. I will give that to you on this quitclaim deed. Well, what does that mean? I'm not making any assurances that I own anything. And that's why whatever I own, I'm giving to you. And in my hypothetical with the Golden Gate Bridge, I happen to own none of it. But I can still create a grant deed, a quitclaim deed that says I'm giving you whatever I own. And good luck, whatever it is. So we have these exemptions here, again, in the top of the deed, parcel number, what kind of deed. And in this example, the person signing that they're getting out of the transfer tax. And the first part of a grant deed, who it's coming from, and then who it's going to. In this case, husband and wife, community property, grants to their trust. The property is in whatever city, and then you put the attachment A, the legal description, and then commonly known as. And in this particular one, an attorney, in fact, was signing part of it, but normally it's not. It's just the declarant. And then we get into the notary and telling the county, send the tax bills to this address above. So that's a quitclaim deed, and it has what they call warranties of title. Another deed that we use for transactions is a trust transfer deed. So what we're saying here is your trust is worthless unless you title things in the name of your trust. So let's do that. We have where the taxes are going. We're saying it's a trust transfer deed. Parcel number, the revenue and taxation codes that will indicate whether you're going to get certain nominal taxes. And we're saying no consideration. It wasn't bought or sold. It's going from, Tweedledum and Tweedledee, husband and wife, as joint tenants. And in this, the wording here says it's granting to them as community property with right or survivorships. And we do that to clarify if a property ever comes out of a trust, it goes back into the character of the property it was before it went into the trust. So that's the purpose of this, first granting it as community property right of survivorship. And the purpose of the right of survivorship is one spouse dies, the other spouse owns it. And then we have a second grant coming out in the same document for husband and wife, community property right of survivorship grants to their family trust, dated. So that's the recipient. Now it's in the name of the trust. It's revocable. They can change it, do whatever they want. Properties in the city of San Jose, legal description required. In this case, there was some lien or easement or things, and then the commonly known address. And don't forget the notary, otherwise you're not going to record. So that's an example of a trust transfer deed. And what makes it a trust transfer deed? Just the heading, that's all. You're telling the world what you're doing. And yeah, so always bring over your legal description. And then what is nice to have is a reference card that shows which taxes are applied or you have exemptions for. In the upper part of the deed, I pointed out that there's transfer tax, there's a lot of different taxes. And so you look through the list of exceptions to find the one that you end up paying the least amount of tax when you record. This list of revenue and taxation code sections is pretty intense. And this other one I got from Sacramento County is a little bit easier to read because of its formatting. And whoa, okay. So these are the code sections. You say you're not going to pay any transfer tax. Why? Because of code section 11911. It's a gift. Fine. Or you transfer between spouses is another one that has no exemption. Is an exemption. Transfer between spouses is exempt from the transfer tax. And the one that we're talking about today was the 11930 that goes into or out of a revocable living trust. So you need to put these on the upper part of the deed because without them, what happens is that the county will put a lot of taxes on it, transfer taxes, that can be avoided. So just to review what's in a deed, where the deed goes after the county puts their official seal on it, what type of deed it is, the assessor parcel number, if you have exemptions from all these filing fee taxes, and who it's coming from, who it's going to, meaning the ownership title. You need to say the state, the county, city and county, because that matches up with the assessor's parcel number is issued by that particular county. You have a legal description and then a commonly known address. Addresses can change, so that's why we don't rely on it. Signed, notarized, and a legal description. So that is an overview of some of the deeds that are used in estate planning. And there are a lot of different types of deeds and other particular circumstances, but this is an overview of the essentials for handling real property deeds in an estate planning situation. If you have additional questions, I'm always able to answer. You can call on our office line or send an email, and we'll be happy to talk with you.